Essentials of a valid customary marriage. The essentials of a valid customary marriage were laid down by Olanu J. in the 1961 case of Yaudi v. Key. In that case, the deceased lived openly with the defendant in Takoradi and in Accra. Upon his death, the defendant provided sponge, soap, perfume and other customary things for the bathing of the corpse and also held the feet of the corpse while it was being bathed. In compliance with the demand by Yaudi's family, the defendant performed all customary rites which a widow should perform for her deceased husband except the custom known as okula, which is confinement in a room for 3 days ending with bathing in the sea on the morning of the 3rd day. The defendant said it was against her religion. The defendant was provided with maintenance during the duration of the funeral and was given mourning cloth for the funeral by the family of the deceased. Later, the family of the deceased, in accordance with custom, gave the defendant in marriage to the paternal brother of the deceased. The brother gave the defendant's family drinks to signify his acceptance of the defendant as his wife. One of the issues that arose was whether there was a valid customary law marriage between the deceased and the defendant, since the deceased never formally asked for the hand of the defendant in marriage. Justice Olanu stated as follows: the question whether the relationship between a man and a woman is one of marriage or concubinage is a question of law to be determined from the facts and circumstances of the relationship. That the defendant was a customary wife of the deceased because on the evidence all the necessary essentials were present, that a marriage under customary law is a lawful marriage recognized by the laws of Ghana. The defendant was therefore the lawful wife of the deceased. Where there is a marriage in fact, the validity thereof is presumed, and when the caprice, avarice, or ambition of a parent has not been excited to force on a marriage, it will be found by careful study of the people and examination of the local marriage institution, that marriage entirely rests on the voluntary consent of a man and woman to give together as man and wife, without intention, desire. Consent and agreement is further evidenced by their living together as husband and wife. If consent of parents cannot be gained either because they improperly refuse to give such consent, or reside in such a distant place that is impossible to obtain consent, then a valid marriage can be contracted if parties agrees to live as man and wife, express agreement, in the presence of credible and respectable witnesses or in the presence of chief, family head followed by the man and woman. Living as husband and wife. The essentials of a valid customary marriage as stated by Olanu were agreement by the parties that they would live together as man and wife, Akorninga v. Akawager. The appellant's daughter got married to one Agambire Adedoku, who was said to be the brother of the respondent. After the marriage, the said Agambire Adedoku died, but at the time of his death, his wife, the woman claimed in the proceedings, was pregnant, and 8 months after her husband's death she gave birth to a baby boy. This boy is one of the 2 children claimed in the suit by the respondent. In evidence, the lady explained that after her husband's death, his family were not feeding her and she had to return to her father's house and only went back to her husband's house to deliver. She said after she had delivered, her husband's family were still not looking after her, so she returned to her father with her baby and stayed with her father for almost 6 years. The respondent's family completely ignored her and her child for the whole period. Her unchallenged evidence is that she does not know the plaintiff. At the end of the 6 years, she left for Kumasi and with her father's consent, married one Atna Acribe with whom she had a child. This child, 5 years old at the commencement of the proceedings, is the second child claimed by the respondent. So, when the suit was commenced, the respondent as the plaintiff claimed his dead brother's wife as his wife and the 2 sons, 11 and 5 years old, respectively, as belonging to him under Frafra customary law, held, under Frafra customary law, on the death of a husband, his successor, or any of his brothers may with the consent of the wife step into the shoes of the deceased husband and be a new husband of the widow. It is a classical case of widow inheritance. If, however, the widow objects, or if none of the brothers or the successor is willing to be considered as a new husband, then the wife is free to go to her father's house and thereafter she can marry any man of her choice. Her family, however, will be obliged to refund either the whole or part of the dowry depending on the circumstances. The appellant is claiming to be a husband of the wife of the deceased with or without her consent, but Frafra customary law does not favor or permit forced marriages or the continuation of marriages by force. The claim of the respondent to be the husband of the woman with or without her consent was inequitable and clearly against the general law of the land because it sought to treat the woman as chattel instead of a human being who had equal rights with her husband. At customary law, there was no age of maturity for males or females to enter into a valid marriage. The age of puberty was the yardstick for determining capacity to marry. However, currently, Section 14(2) of the Children's Act, 1998 sets the age of maturity at 18 years. The consent of the parties is fundamental to the institution of marriage at customary law. Therefore, a marriage may be held to be invalid for lack of consent because of insanity on the part of one party, mistake as to the identity of the other party, or because the will of the other party was overborne by duress or deceit. Consent would also be void if the person giving it is below the age of 18 years. B. Consent by the family of the man that he should have the woman as his wife. Consent may be actual, formal, i.e., by the family of the man going to the family of the woman formally to ask for her hand, or it may be constructive, informal, i.e., by the family of the man recognizing the woman as the wife of the man and admitting her and her family to performance of customary rites for their family. E.G. Funeral rites where there is bereavement in the man's family. In Jarbang v. Tago, the court noted that customary law required the consent of the two families concerned to any marital relationship between a man and a woman. When a man desired to marry a woman customarily, he applied to the woman's family through his own family for their consent, taking to them certain gifts which would vary according to his means. The family of the woman would give their consent by accepting the gifts. Where the consent of the woman's family would not be gained either because they improperly refused to give such consent or because they resided in such a distant place that it was impossible to obtain such consent, a man and woman who voluntarily agreed to live as man and wife for life could contract a valid marriage provided that such agreement was expressly made in the presence of credible and respectable witnesses or in the presence of the chief or headman of the place, followed by the man and woman living as husband and wife. In Kivi Kavi, the court further noted that although it is highly desirable that a person seeking to establish a marriage should be able to point to the giving of the girl's parents and acceptance by them of rum as evidence of their consent to the marriage, yet the inability to show that such a ceremony has taken place would not of itself be sufficient to invalidate a marriage if the consent of the parties to the marriage were proved by other means and if it were also proved that the parties had lived together in the sight of the world as man and wife. C. Consent of the family of the woman that she should have the man for her husband. This consent too may be actual, i.e., where the family of the woman accept drinks offered by the family of the man, or it may be constructive, i.e., by acknowledging the man as husband of the woman, and admitting him and his family to perform customary rites for their family, e.g. funeral rites on occasion of bereavement in the woman's family as was done in Asuma v. Care. Consummation of the marriage by cohabitation. In Soa v. Soa, the man was in England and the woman was in Ghana. The family of the man performed the necessary rites and the woman's family gave the woman's hand in marriage. The court held that a valid marriage had come into existence even though the parties live miles apart and the marriage was not consummated. The four essentials were reiterated in Re Caveat by Clara Sacady. In that case, the issue was whether there was a subsisting customary marriage to bar a prospective ordinance marriage to another woman. Criticisms of the essentials. The essentials have been criticized on the following grounds. There are certain areas in Ghana where drinks are not accepted as a bride price. How does one satisfy essentials 2 and 3 when custom demands the bride price should, for example, consist of cows and cola? The type and quantity of drinks are also not specified. Justice Alino failed to define family. Should family here be taken to mean nuclear family or extended family? It is not clear who in the family should accept the drink. Should it be the father, the mother, or the head of family? Difficulties could arise where the head of family, for no apparent reason, refuses to accept the drinks. Would it mean then that the parties cannot marry, or that if they did, the marriage would be invalid? There could be cases where the family is far away and cannot be reached. The definition of consummation is not given. If consummation is defined as sexual intercourse, then how does one establish that sexual intercourse has taken place? Should mere cohabitation by a man and a woman mean that sexual intercourse has taken place? And conversely, Should non-cohabitation mean that sexual intercourse has not taken place? Should procreation per se be used to establish consummation? What about couples who choose not to have children? Others could have children through artificial and scientific means? There are also situations where a man may be unable to perform sexually as a result of impotence but still in a valid marriage. In Soa v. Soa, the man was in England and the woman was in Ghana. The family of the man performed the necessary rites and the woman's family gave the woman's hand in marriage. The court held that a valid marriage had come into existence even though the parties live miles apart and the marriage was not consummated. If Justice Olanu equated consummation to cohabitation, then why did he simply not say consummation by cohabitation? What then is the definition of cohabitation? Another difficulty that the essentials pose is whether all four essentials must be present before a valid customary marriage can come into existence. Some judges insisted, rather erroneously, that family consent is a condition precedent for the creation of a valid customary marriage and further that all four essentials must exist for valid customary law marriage to come into existence. In Jarbang v. Tago, the plaintiff sued the defendant, inter alia, damages for breach of promise to marry. The court held that customary law requires the consent of the two families concerned to any marital relationship between a man and a woman. Where a man desires to marry a woman customarily, he applies to the woman's family through his own family for their consent. The decision implies that even a promise to marry is not valid without customary approval. Justice Osewar in Badu v. Bokai asserted that the presence of all four essentials must be real and not notional. Badu v. Bokai, facts. The plaintiff sued the defendant for damages for an alleged breach of promise to marry at customary law. Damages for assault and battery and an order directing the defendant to pay her cent 100.00 as medical expenses. The plaintiff alleged that she was married to the defendant around the Easter of 1969 after she had been conceived by him. They lived together thereafter as man and wife until 1970 when she was asked to leave the matrimonial home by the defendant because he no longer wanted to continue the marriage. The defendant subsequently threw out her belongings and when she tried to put them back, she was seriously assaulted by the defendant as a result of which she was admitted to the Barikam Hospital and operated upon. The defendant was however not prosecuted for the assault committed on the plaintiff. The defendant in his evidence admitted that he had been living with the plaintiff, but however denied that it was a husband and wife relationship. He alleged that 2 months after meeting the plaintiff, he presented some drinks and money to the plaintiff's parents and family as Akatoagian to enable him to consort freely with the plaintiff, with the hope that if he found the conduct of the plaintiff suitable he would marry her. On realizing that the plaintiff would not be a suitable wife, he again presented drinks to the family of the plaintiff to terminate the Akatoagian relationship. The main issues for the determination of the court were a. Whether the payment of Akatoagian constituted a valid marriage or an unconditional promise to marry at customary law. b. Whether a woman staying with a man under the Akatoagian custom was entitled to sue for maintenance or a breach of promise to marry, inter alia, held, at custom. Akatoagian was the drink provided by a man to inform the parents of a woman with whom he was cohabiting about the fact of their concubinage. The drink provided might be either 1/2 bottle or a full-size bottle of schnapps and, as the name implied, it meant bottle, taken, for nothing or drink, taken, for nothing. The providing of Akatoagian created no legal relationship between the man and the woman as the drink was not refundable if the woman decided to bring to an end their concubinage, and the woman could not claim any damages for breach of promise if the man decided to break their relationship as it did not serve as a token of a promise to marry. Neither could a woman living in concubinage sue the man with whom she was so living for any maintenance. The presence of these essentials must be real and not notional. So that where a man lives with a woman not as a real wife but only as a concubine with the consent of the woman's parents, that association cannot be translated into a valid customary marriage because the man and the woman are reputed to live as man and wife. Even though the defendant freely described the plaintiff as his wife and he also described their association as marriage, this was no more than another euphemism for concubine and concubinage respectively. The Akatoagian practice has however been criticized as being obsolete by the court in Abanguna v. Akalogo. Abanguna v. Akalogo, An appeal was made from the decision of the Grade II District Court, Balga, where the court upheld the claim by the plaintiff respondent for the return of his lawful wife and 2 children and damages for seduction against the defendant appellant. The plaintiff married one Abagpoka, a Frafra woman, and performed all necessary customs. Not long after the marriage, the woman ran away from the plaintiff and traveled to her brother in Accra, where she met the defendant, a Frafra. They decided to marry. Following this decision, they traveled to see her parents to perform the necessary marriage customary rites for the formal recognition of their union. When they arrived, the defendant was informed that the Abagpoka was already married to the plaintiff. She was therefore taken away from the defendant and given back to the plaintiff. She ran back to the plaintiff in Accra. The plaintiff therefore decided to give up the marriage and claim back all he had spent on the marriage. The defendant expressed the desire to pay the plaintiff back all that he had spent on the marriage, but unfortunately for him, Abagpoka's father died before he was able to refund the expenses to the plaintiff. Held, criticizing Badu v. Bokai, that the Akatoagian custom is unreasonable and has the effect of throwing women back into the slave trade days. On grounds of public policy and the established practice of the courts, it should have been held to be repugnant to equity, good conscience, and natural justice, and should not have been given the blessing of the court. The sole question to resolve is whether a custom which deprives a person of his or her natural child is repugnant to principles of equity, good conscience, and natural justice as to be rejected. The 2 children involved were born to the defendant and the wife of the plaintiff, who were staying together for about 5 years, and even though the trial court found as a fact that the attitude of the woman in dispute towards the plaintiff was a clear indication of no love between them, yet it sought by a court order to get the woman back to the plaintiff. The principle of law relevant here is that equity does nothing in vain. If therefore the trial court found as a fact that there was no love between the plaintiff and his wife and that the continued stay of the 2 depended on the existence of love, then its order asking the woman to go back to the plaintiff was wrong. The order that the defendant should hand over his 2 children to the plaintiff, a stranger to the union that brought them into being, solely on the basis of a customary rule of practice, is repugnant to principles of equity, good conscience, and natural justice, and also contrary to the accepted principle accepted as paramount in considering granting custody of infants, namely, the welfare of the children. Article by Kofi Adinkra, Essentials of a Customary Marriage, a New Approach, Agreement by the Parties. Not much is likely to turn on agreement of the parties themselves. The only problem that can be foreseen in this regard is betrothals, where a young girl is given in marriage to an older person. Such girls are too young to give consent one way or the other. Thus, it doesn't help to use contractual principles to say that if she attains the age of majority and does not repudiate the marriage, she must be deemed to have affirmed the marriage. The customary law had no such age requirement, even though specific modern enactments now forbid such practices. And in any case, even in their absence, the courts can on their own annul such marriages on public policy grounds if a party can show that he was forced into the marriage. Apart from this, one can safely infer the requisite agreement from the fact that the parties are living together, consent of the spouses' families. If parental consent were to be a true legal essential, it should be strenuously argued by or for the party in whose favor such issue was raised when the opportunity presented itself. This, however, does not seem to be the case. In Asuma v. Care, for instance, a girl who had a valid subsisting marriage deserted her first husband and came to live openly with the defendant, becoming pregnant by him. The plaintiff here was the girl's father, and he sued the defendant for seduction. This implicitly ruled out his ever consenting to the defendant's alleged marriage to the girl. The court nevertheless went ahead to find a customary marriage between the defendant and the girl proved. The question of parental consent was therefore silently passed over by the plaintiff, the defendant, and by the court. Sarba, in his book, Fanti Customary Law, further casts doubt on the validity of this requirement. He stated that in earlier times, when parental authority and influence over their wards was unquestionably greater, parties sui juris could validly marry in the absence of such consents. They could do this even if parental consent had been refused, for in that event, they could agree to marry before respectable witnesses or before a chief of the village or the tribe. Therefore, if it could be said that even at the close of the 19th century when Sarba wrote, parental consent to marriage was not a legal necessity, it can only be modestly said that it would be even less so in our vastly changed social circumstances today. Today's observable social fact also points to the conclusion that parental consent amounts to no more than the passive ratifications of a relationship, marriage, that is a fait accompli for all intents and purposes. This is often the case where the spouse live in the cities and town while their parents live in the rural areas. In that event, the lady and gentleman take each other for husband and wife and then visit their villages to introduce their husbands or wives, as the case may be, to their respective parents. Drinks. While it may be common practice to present drinks and is important, the question is whether failure to give drinks invalidates a marriage. Is the giving of gifts during the marriage to be distinguished from drinks? Are the drinks shrouded with essential formality because they are presented at the marriage ceremony? In any case, who is supposed to receive the drinks? Is the same person who receives the drinks the person supposed to return it upon dissolution of the marriage? The problem arises where in these modern days, mothers or sometimes brothers not in loco parentis but acting on their own initiative give away brides or tacitly acquiesce in the already formed relationship and receive drinks from the suitor. Do they act ultra vires if it is shown that they are not in loco parentis and that no such authorization was delegated to them by the proper person? In such circumstances, is drinks paid to these unauthorized receives nevertheless enough to satisfy this legal essential? Cases such as Engman v. Engman and Asuma v. Kerr shows that a marriage is perfectly valid even if payment is ignored. This was also acknowledged in Key v. Kevi. Sarba further mentions that the payment to the bride's family is made according to the means of the prospective groom and that among the poorer classes none is given and yet their unions are perfectly legal. Rattray also notes that among the 6 different forms of marriage among the Ashanti, with Mpina Awadi, no drinks pass. Any insistence then that drinks be a legal essential to a valid customary marriage, therefore, seems to stand on doubtful legal and social foundation. Consummation, what is the legal meaning assigned to it? Does it have the same meaning as in Western law? i.e., sexual intercourse? If it does, how is sexual intercourse to be proved in order to establish the marriage? At common law, non-consummation of the marriage due to impotence is a ground for nullity. Should non-consummation of the customary marriage have the same consequence? In conclusion, while not completely doubting the significance of the various procedures in contracting the customary marriage, it is clear that no meaningful and helpful distinctions can be made between those acts that are legally necessary and those that are merely desirable but with no legal significance. Conclusions to be drawn in respect of the essentials. The agreement between a man and a woman to live as husband and wife is the most important of all the essentials. Consummation need not be established to prove the validity of a customary law marriage. Family consent is merely desirable and the absence of it should not render an otherwise valid marriage invalid. All 4 essentials need not be proven in order to create a valid customary law marriage. Insistence on family consent, as happened in Badu v. Bokai, could lead to undesirable consequences. The question whether the relationship between a man and a woman is one of marriage or concubinage is a question of law to be determined from the facts and circumstances of the relationship. Types of customary marriages. There are 2 types of customary law marriages: formal and informal marriage. Formal marriages. A formal marriage comes about when the family of a man approaches the family of a woman and asks for the hand of the woman in marriage on behalf of their son. A day is agreed upon for the formal ceremony to take place if the woman agrees to marry the man. On the appointed date, the family of the man and the family of the woman hold a meeting and the necessary rites are performed according to custom. Drinks and gifts are presented by the man's family to the woman's family. The family inquires from the woman if she agrees to take the man as her husband. If she answers in the affirmative, her family accepts the drinks and the gifts and the marriage is concluded. The man and the woman then become husband and wife. In formal marriage, the following cases illustrate the circumstances in which informal marriages may come about. In Key v. Kv, the man sent drinks to acknowledge responsibility for the girl's pregnancy. Thereafter, the 2 lived together as husband and wife even though no drinks had been presented by the man's family to the woman's family. asking for the woman's hand in marriage, the court held, quoting the words of the Ga Manche, if through illicit intercourse a girl gets in a family way for a boy, the girl's parents send to the boy's parents, and if the boy admits the act, his parents send the customary rum signifying his admission. If the rum is sent and accepted, the girl is recognized as a wife. The court further added that although it is highly desirable that a person seeking to establish a marriage should be able to point to the giving of the girl's parents and acceptance by them of rum as evidence of their consent to the marriage, yet the inability to show that such a ceremony has taken place would not of itself be sufficient to invalidate a marriage if the consent of the parties to the marriage were proved by other means, and if it were also proved that the parties had lived together in the sight of the world as man and wife. In a summa v. care, the man had married the woman by performing all the necessary marriage rites. The couple, however, never lived together as husband and wife. A friendship developed between the woman and another man. The other man refunded the marriage fees and all other expenses to the woman's father to be given to the woman's husband. The new man, Care, and the woman lived together as husband and wife. A child was subsequently born. The girl's father later brought action against Care for seducing his marriage and claimed damages from him. The Court of Appeal discussed the various means of contracting a valid marriage, the formal and informal means. A. When a man intends to have a certain woman for his wife, he applies to her family, asks her to be given in marriage, by taking to the family, according to his means, 2 flasks of rum or 2 akirs of gold dust, or 4 or 6 according to his means. Upon this, if the family approves, they agree to give the woman. The request and the consent with the first present alone make a valid marriage. Formal means. The Court of Appeal, however, noted that there are other forms of a valid marriage, informal marriage. B. Thus, a girl becomes pregnant and her husband, upon discovering her condition, ascertained from her who was responsible. They send to the man to ascertain from him. If the man sends some drinks admitting liability and sends a further drink or present, and if the girl's family accepts the present in addition to the fee admitting liability, a valid marriage is thereby concluded. By custom, the sending of the additional drink or present amounts to a request by the man of the hand of the woman, and the acceptance of that additional drink amounts to consent by the family. Impregnating, sending of drinks acknowledging paternity, sending of additional drinks. C. Where a man has obtained the consent of a girl's family and has completed the marriage by making the token gift, and another man interferes with his wife, 2 remedies are open to him. He may claim adultery fee from the offender and keep his wife, in which case any child born in consequence of that illicit relation is by customary law a legitimate child of the husband and be given a name by the latter. On the other hand, the husband may elect to break the marriage, and to claim the return of all the customary drinks or fees and presents which he has given to the family of the girl. In the latter case, the family will refund those customary fees, and in turn, claim the same from the seducer. If the offender pays the amount which the family had to refund, he steps into the shoes of the former husband and is deemed to be validly married to the girl. So in this case he does not send a second drink. D. A woman who has been married according to custom may not have been cohabiting with her husband, and declines to cohabit with him. It is discovered that she is being induced by another man to break the marriage. If that other man is willing to marry her, the girl's family would obtain the consent of the husband to break the marriage formally, and would refund to him all the expenses which he had incurred on the customary fees and presents. When that has been done, and the new suitor has paid that same amount to the family, he steps into the shoes of the original husband and becomes the lawful husband of the girl. Another form of informal marriage is where a man and a woman are acknowledged as husband and wife by their respective families and are treated as such by them, when no drinks have been presented. Thus in Youty v. Key, Justice Aleno held that there was an informal marriage because the evidence showed that the family of Youty had acknowledged the defendant as Youty's wife even though no drinks had been presented. In Esselfi and another v. Quarku, following the death of the deceased, her mother and her sister jointly applied for letters of administration to administer the estate. The defendant, claiming to the husband of the deceased and father of her 2 children caveat. The plaintiffs argued that the defendant was a concubine and therefore the deceased's property devolved solely on them. evidence was led to show when the defendant impregnated the deceased, his family sent drinks to acknowledge responsibility. Thereafter, the defendant and the deceased lived together in the deceased's house for 7 years before she died when giving birth to their second child. The court also established that the mother of the deceased, the first plaintiff, had been visiting the couple in their house and that on the death of the deceased's father, and at the request of the plaintiff's family, the defendant performed the customs required of a son-in-law. When the deceased died, the defendant at the request of the deceased's family provided the shroud and the grave used in burying her. Furthermore, the deceased on beneficiary nomination forms, filed with her employers indicated that she was married. The court held that there is the ordinary form of customary marriage, where the necessary ceremonies of payment of drinks, customary fees and dowry are given by the man's family to the woman's family. And there is the second type where although the customary rites have not been performed, the parties have consented to live in the eyes of the world as man and wife and their families have consented that they should do so and the parties actually live as man and wife in the eyes of the whole world. The court decided that the second type of marriage had been proved and that the defendant was the husband of the deceased. Consequently, the defendant is better entitled to the letters of administration than the plaintiff. The court further added, with reference to the obiter in Adade v. Dade, that registration of a customary marriage is not a condition precedent or sine qua non to the enjoyment of rights or benefits under PNDCL 111. It must be emphasized that the most important essential of the 4 essentials is the agreement between a man and a woman to live as husband and wife. There must, however, be evidence to show that the parties in fact lived as husband and wife. Cohabitation for a considerable length of time coupled with having children together, acquiring joint property, attending functions together and performing customary rites in each other's family will also lead the court to conclude that there was an informal marriage. Common features of customary marriage. A. Customary marriages are potentially polygamous. The man is entitled to marry as many wives as he can harmoniously live with and conveniently manage as stated in Graham v. Graham. The marriage continues to be potentially polygamous until the man marries additional women. A mere promise by a man to his wife not to marry additional women does not change the character of the marriage. The marriage remains potentially polygamous as B. The parties must have capacity to marry. Some marriages are prohibited on grounds of consanguinity, i.e., blood relationship, or affinity, relationship that springs from marriage and exists between the relations of one spouse and the relations of another spouse. Under customary law, prohibition of intermarriages arising from affinity is generally observed because of the fact that customary marriage is considered to be a union not just of one man and one woman but also of a union of the family of the man and the family of the woman. Age is also an important factor to consider in determining capacity. Section 14(2) of the Children's Act, 1998 provides that the minimum age of marriage of whatever kind shall be 18 years. C. A significant feature of customary marriages is therefore the involvement of the families of the parties to the marriage. Alanu J. in the Yaudi v. Key case thus stated that one peculiar feature of our systems of marriage which distinguished it from the system of marriage in Europe and other places is that it is not just a union of a man and a woman, it is a union of the family of the man and the family of the woman. D. It imposes rights and duties upon the two families. The woman's family gains the right to perform certain rites in certain eventualities, and the man's family also gains the right to perform certain rites in certain eventualities. Under customary law, a husband is responsible to provide maintenance and accommodation for the wife. After his death, that responsibility devolves upon his family. E. Customary law and ordinance marriages are mutually exclusive. One is potentially polygamous, and the other is monogamous. The two cannot coexist. It follows that a man married under customary law cannot enter into a valid marriage with another woman under the ordinance unless the woman married under customary law is first divorced. The second marriage will be null and void. F. A customary law marriage may be converted into an ordinance marriage. When this happens, the customary marriage falls away automatically. In Graham v. Graham, the court held that after the solemnization of the marriage under the ordinance, the customary law marriage ceased to exist. G. A man married under the ordinance cannot enter into a valid customary law marriage or another marriage under the ordinance with another woman. This would amount to bigamy, which is a criminal offense. The second marriage will therefore be void. H. Customary law marriages have become synonymous with engagements. The ring, which is not part of the customary law marriage, is now invariably given at traditional weddings. The Bible and ring do not form part of customary law marriage but may be given by the man to the woman. The giving of the Bible and the ring shows an intention to marry under the ordinance and can form the basis of an action for damages for breach of promise to marry under the ordinance. In Afrifa v. Class Peter, the court noted that the gifts of a ring and a Bible are also significant, for rings and Bibles are unknown in customary marriages. They are essentially Christian symbols and in concept denote an intention to marry in a Christian monogamous fashion. I. The existence of a customary law marriage is not a condition precedent to the creation of a valid marriage under the Marriages Act 1884 to 1985. The requirements for the creation of a valid ordinance marriage are clear. The existence of a customary law marriage is not one of the requirements. Some churches may, however, demand the existence of a customary marriage before a church marriage ceremony. J. Note that the knocking ceremony is not a marriage ceremony. It merely reinforces the parties' promise of marriage to each other. It may form the basis of an action for damages for breach of promise to marry. Registration of customary marriages. The registration of customary marriages and divorces is governed by Part 1 of the Marriages Act, 1884 to 1985, which was previously separately the Customary Marriages Divorces Registration Act 1985, PNDCL 112. PNDCL 112 was promulgated to facilitate proof of the existence of customary law marriage, especially in respect to inheritance and succession matters, and to also assist in keeping track of a number of customary law marriages existing in the country. Until the passage of the Intestate Succession Law PNDCL 111. Since the deceased husband's family succeeded to all the properties of the man, the existence or otherwise of a customary marriage was a serious issue. Most families did, in fact, prevent some surviving wives from performing the requisite funeral rites so as to prevent them and their children from benefiting from the man's estate. It was to forestall the above unfortunate development and aggrieved families denying the existence of customary marriage, especially with the enactment of PNDCL 111, that PNDCL 112 was enacted in 1985. Law 112 initially made it mandatory for all customary marriages to be registered within 3 months after the celebration of a marriage. The law was also made retrospective in that marriages contracted before the passage of the Act were to be registered within 3 months from the date of the promulgation of the law. This mandatory requirement was, however, done away with in an amendment to the law in the Customary Marriage and Divorce Registration Amendment, Law PNDCL 263, 1991. The amendment made, inter alia, the registration of customary law marriages optional. Law 112 together with the amendment is now part of Part 1 of the Marriages Act. Section 1 of the Act states that a marriage contracted under customary law before or after the commencement of the Act may be registered in accordance with the Act. Where a marriage is contracted under customary law, either party to the marriage or both may apply in writing to the registrar of the district in which the marriage was contracted for registration of the marriage in the Register of Marriages. The application may be made at any time after the marriage. Section 2. The following particulars must be stated in the application: a. The full names of the parties, b. Their ages and place or places of residence, c. Whether the husband has another wife, d. Whether the wife is a spinster or a divorcee. The application shall be signed or thumbprinted by the parties and their witnesses. Per Section 3, 1, the application must be accompanied by a statutory declaration stating a. The names of the parties to the marriage, b. The places of residence of the parties at the time of the marriage, and c. That the conditions essential to the validity of the marriage in accordance with the applicable customary law have been complied with. Section 3, 2.